Welcome to The Explainer. Today we are diving into a really fascinating legal puzzle that affects a lot of people. We're talking about how a divorce from another country can be recognized in the Philippines, a country that famously doesn't have divorce. So let's get into it and untangle this legal knot, one piece at a time. So just imagine this for a second. You're a Filipino citizen and you marry a foreigner. Things don't work out, and you get a divorce abroad. Your ex-spouse? Well, they're free to move on. They can even remarry. But what about you? Are you stuck? This very question is really at the heart of what we're talking about today.
Okay, so before we get to the solution, we first have to understand the core problem. And it's this very strange and, frankly, deeply unfair legal limbo that for a long time trapped a lot of Filipinos who were in mixed marriages.
Now, the story starts pretty simply. Philippine law is actually very straightforward on this. If you get married in another country, and that marriage is totally valid there, then it's also considered valid right here in the Philippines. This whole idea makes international marriages possible, but, as we'll see, it also sets the stage for a really complicated problem. And this brings us right to the main issue, a situation that lawyers have a great name for, a limping marriage. Look at the contrast here. The foreign spouse could go to their home country, get a divorce, and under their law, poof, they're single again, totally free to remarry. But the Filipino spouse? They were completely stuck. Back in the Philippines, they were still legally married to someone who, for all intents and purposes, was no longer married to them. It's a truly bizarre and absurd situation, right? So how in the world do you fix a situation that's so unfair? Well, eventually, the law provided a key. It's a very specific provision that was designed to unlock this legal trap. Let's take a look at how this door was first opened.
This is it. Paragraph 2 of Article 26 of the Family Code. It was written specifically to address that limping marriage problem we just talked about. The goal was simple. If a foreign divorce sets the non-Filipino spouse free, it should also set the Filipino spouse free. It was a huge step towards fairness.
But, and this is a big but, the original wording of the law was very, very strict. You had to check all three of these boxes. And I want you to pay really close attention to step 2. The law specifically said the divorce had to be obtained by the alien spouse. So you can probably see the problem this created, right? What if the Filipino was the one who filed for divorce? Or what if they filed for it together? The law was totally silent on that.
And that silence, well, it led to a major legal battle. A landmark case that absolutely changed the game. This is a story of how the Supreme Court decided to look at the spirit of the law, not just the exact words on the page. So meet Marilyn Manalo. She was married to a Japanese national. Their marriage ended, and she was the one who actually went to court in Japan and got the divorce. But when she came back to the Philippines to have it recognized, she was denied. And the reason? Because she, the Filipino, was the one who filed for it, not her foreign husband. And that went against the strict text of Article 26.
But the Supreme Court saw it completely differently. And this quote just brilliantly lays out their reasoning. They looked right past the literal words and focused on the purpose of the law. They said the whole point was to prevent this exact absurd situation. Who filed the paperwork doesn't change the basic fact that the marriage was over for the foreigner, so it should be considered over for the Filipino too.
And that's the key takeaway right here. This was a massive shift. Before the Manalo ruling, it was a one-way street, period. After Manalo, it suddenly didn't matter who started the divorce proceedings. The court basically said that treating people differently just based on who filed the papers is arbitrary, and it violates the constitutional promise of equal protection. It was a win for justice over a technicality. The Manalo case really did open the floodgates. After that decision, the Supreme Court started applying the same principle of fairness to other similar situations, and what emerged was a really clear and consistent legal trend.
This timeline really shows you how the principle grew after Manalo. You can see the pattern. In the Racho case, the court said, yep, a divorce by mutual agreement is valid. In Abel, they confirmed a jointly filed divorce is also perfectly fine. And then in Bayog Saito and the more recent N case, they've just hammered the point home again and again. It does not matter how the divorce was obtained, as long as it was valid.
Okay, so we've covered the why, the legal reasoning behind recognizing these divorces. But what about the how?
What do you actually need to do and, more importantly, prove in a Philippine court to make your foreign divorce official? At the end of the day, it really boils down to these two essential pieces of evidence. You can't just walk into court and say you're divorced. First, you have to present the official document, the divorce decree itself. And second, and this is just as critical, you have to prove that the foreign law that allowed for that divorce actually exists.
Now, this is a really common question. People often succeed in getting an authenticated copy of their divorce papers, but proving a foreign law, that can be tricky. So, does your whole case just get thrown out if you miss that second part? And the answer, thankfully, is no. The Supreme Court, in cases like Kukichi and Ni, has shown that it favors a policy of liberality here. So instead of just dismissing the case on a technicality, they'll send it back, the legal term is remand, to the lower court. This gives the person another chance to present the correct proof of the foreign law. The focus is really on getting it right, not just on procedural perfection. All right, one last but very crucial tip. The petition to recognize the divorce is legally a separate thing from the petition to actually change your name and status on your official records, like your marriage certificate. As the Ordoneza case pointed out, that second step has its own strict set of rules about where you have to file and who needs to be involved. So remember, recognition is step 1, fixing the records is step 2. And that brings us to our final thought for today. This entire legal journey, from a very strict, literal rule to a much broader, purpose-driven interpretation, it shows a clear evolution in legal thinking. The courts have consistently expanded the path for Filipinos to find freedom from broken international marriages, and it leaves us with a really compelling question to think about. What do all these decisions signal for the future of marriage and family law in the Philippines itself?